Hey everyone, welcome back. This is Cathleen Scott. I'm here with my partner, Gabe Roberts. We're on the Cathleen Scott podcast, where today we're talking about a very new law and some legal changes that happen. If you watched some prior episodes, you know that this was in the works. And so breaking labor and employment law news, the Choice Act is now officially law as of July 1, 2025. So let me turn it over to Gabe and just give us a quick little, hey, what does this mean to anybody who cares about non-competes?
Choice Act, it feels like it's been the boogeyman of labor and employment law in Florida for the past month of all of us trying to figure out, is this going to happen or not happen? What is Governor DeSantis going to do? And it turns out he's going to do nothing and allow it to go into law without his signature.
Let's just talk about the name, okay? What the heck? Right. What does that even mean? Are you ready to break down the acronym?
I can pull it up here. I have the law.
Florida Contracts Honoring Opportunity, Investment, Confidentiality, and Economic Growth.
Like a lot of laws, I think lawmakers work backwards from the acronym they want, right? There's a lot of things that they're like, oh, choice, that sounds fun. Let's try to think of some word salad that creates that. And I don't see the choice in this law or the opportunity or economic growth. I think it actually does the opposite of all the things it says there in practice, but it sounds nice.
Yeah. So it's a non-compete bill. And I think that's really a term of legal art in some ways, right? Because we think about people use the word NDA, like a non-disclosure agreement. That's not affected by this new bill, right? It's just, it has to fall into this very specific definition of non-compete. One of the things that struck me when I read it, and I'm curious for your feedback, is in kind of comparing it to the existing non-compete statute, which is actually a more broader statute, covers things like NDAs. This bill, the so-called Choice or Not Choice Act, it uses words like, if you're engaged in similar employment. If you compare that for a minute to the prior act, it uses words like competition. I kind of think that there's a difference there.
Yeah, because there can be a lot of things you're doing that are similar that aren't competitive, right? You could be in the same industry doing a similar type of work, but you could be working towards a different customer base where there's no overlap or there's no competition. Or maybe, this is an analogy I give sometimes when I'm doing consultations, is picture hypothetical customer A. If customer A could only choose to work with you or the other company, then you're probably competitive. But This is much more broad than that, where it's even if customer A could work with either company and they're not mutually exclusive, if they're similar, it's potentially covered.
Yeah, it's a lot. So I think I was giving the example, if you work for Chewy, which, by the way, just a shout out to Chewy, it's probably one of the best places to get your dog's supplies. It comes delivered to your door at about 20-30% less than what you'd buy it off the shelf in a grocery store.
Is this going to be? Did someone?
This is going to be and I actually very much like the in-house counsel for Chewy, and I have struck up a friendship. So even though this is not at all sponsored by Chewy, no. I do think. So let's say you're an employee and you work.
It's not a situation of someone paid you $100 to eat dog food on camera, and then you thought it was human food. No, you've not been Laura Lumered.
And I definitely would not do that unless it was a survival situation. But if you work for Chewy and you're selling, and you're operating under this new statute, what is a similar employer, right? So I'm thinking similar would be like a grocery store that sells pet food, right? Even Amazon sells pet food that can be delivered to your door. But when we talk about competition, when we're talking about things that are kind of like in derogation of common law, meaning like telling someone they cannot work competitively, usually it's a much more narrow analysis. But this bill says we're not worried about competition. We're worried about similarity. And so, and let's just really put this into example. So I work for Chewy. I'm happy, but somebody offers me more money to leave Chewy and go work at another competitive place, maybe like PetSmart or Petco, who's now delivering pets care products to your door. That's competitive, right? And if Petco wants to offer me twice my salary to leave, I might be interested in that. It might be in my family, in my own best interest to do that. If I've signed a non-compete after July 1, I can't do that. And worse, I can maybe not be able to do that for 4 years under this new bill because it's similar. Whether or not it's competitive, it's similar. They can't even hire me to put me in training roles or things that we would do to kind of ride out the non-compete, and so I really wanted to kind of flesh out what that means for employees. So people okay, I signed a non-compete for 1 year, 2 year, 3 years, I agree to that, and I have to sit it out.
Right, and To go back to your analogy, I think the analogy is like Kroger, right? Kroger delivers groceries to your door. And so if Kroger delivers dog food in the same way that Chewy delivers dog food, this could say those are similar, even though they're not actually competitive with each other, right, as an overall business model, right? And that's where the issue comes in. And it's also who decides what is similar. It's the former employer, right? So in this situation, you leave Chewy to go work for Kroger. It's whoever your boss was, whoever maybe your good friend, the in-house counsel at Chewy. They're the ones who says, well, we think that's similar and we're going to, file a suit against you. And the judge is required to stop you from working at Kroger without anything else happening, right? The judge doesn't get any say in it. They have to issue this injunction and immediately say, no, you can't do that.
So wait, yeah, that is interesting language in the statute. It's a must.
Right.
The statute says the court must enjoin the employee who's engaged in similar activity who is signed to non-compete under this agreement. So there's not even like judicial discretion. There's no like narrowing it to the individual circumstances or like looking at the employee's defenses. Like maybe they left because they were being sexually harassed. Maybe they left because they weren't paid properly. I mean, who knows, right? People leave jobs for lots of reasons. I just have to say, like, choice to me means free competition, and this act is kind of like, is in my legal opinion, is anti-competition, because if you're really a great employer and people want to stay and work with you, that's why people stay and work with you. We don't have restrictive covenants in our firm, and we've got people who've been there for 20 years, and that's because we try to make it a great place to work. But tying people down and telling them you can't have upward mobility, you can't go to a different job, and up to 4 years, that to me is not competitive. That's, in my view, is a little anti-competitive. But to be fair, we understand, like, employers I wouldn't begrudge an employer the opportunity to protect their restrictive covenant, to protect their trade secrets. It just seems like, to your point, like the employer has all the control here. They decide how long, and they decide whether they're going to pay you. And at any moment, they can be like, okay, just kidding. I know you've sat out for 6 months. We're going to stop paying you now, give you notice, so you're free to go. So now you find yourself without a job, and while you're free to compete, the offer that you had that you wanted to take is now, expired. And it's really hard to like plan your life around that when everything's really up to the employer.
Yeah, and you're paying an attorney to try to get this court order lifted so you could go there, and that's expensive, and most people can't afford to do that, and so choose not to, and then their life's uprooted. I mean, you brought up a good point about there being alternatives, and that's something, if we take a step way back before this law is even proposed, a lot of it's in response to what the Federal Trade Commission or the FTC did last year, where they put out this proposed rule that would have banned non-competes nationwide. And the reason they did that is they did all this research and they made all these findings that said there are alternatives that you can do as a company to protect your trade secrets, your customer list, your confidential information, right? You can do a non-solicit, you can do a non-disclosure, you can do all these things that protect the things you're actually trying to protect. But instead, you're doing a non-compete that just goes so beyond protecting the things you actually want to protect, and it's basically just a way to say, I'm controlling you, right? It creates this sort of like peasant serfdom situation of, I as your employer can only say where you can work.
Yeah, and I think it's important for listeners to hear, like, we're not just pontificating and making up things here. I think it's important that people hear the intent in the legislative statute. So I want to, and my producer Dylan is going to be upset that I'm looking at my phone here, but I promise it's just to read out the legislative intent, because I can't memorize that. I mean, I suppose I could, but that would not speak very highly about my life. And so the legislature says that the Choice Act was enacted for two important legislative findings. This is like an 8-point font, so I apologize if I'm going slow here. They say that the alternative means, what you were just talking about there, to protect confidential information and client relationships, such as non-disclosure agreements and various types of non-solicitation clauses and employment contracts, are inadequate to protect them. That's legislative finding number one. Second thing they say is that the legislature finds that you need to have predictability in the enforcement of contracts. So let's have some fun breaking that down, because I think it is fun. So let's start with the last one first. So how does it create predictability in the enforcement of contracts? And this I just have to laugh out loud, because the employee literally does not know how long they have to sit out, because it's from 1 day up to 4 years, completely at the discretion of the employer. And so How is that, so how is that predictable, right? Like I'm an employee. I'm being told that I have a restrictive covenant. I've now quit my job and I might have to sit out for 6 months or 4 years. I just have to wait for my employer to tell me and then live every 30 days wondering, will this be the month that they decide that I can now go live my life and work and live where I want to?
And also part of the coverage here is based upon wages, right? Like how much you earn. To be covered by this, you have to earn, your salary needs to be twice the annual mean wage in the county you're in. And that's going to change year to year because it's based on Department of Labor statistics. So talk about predictability. Like how are we supposed to predict what somebody's, annual mean wage is going to be from year to year? And depending on what your salary is, are you going to fluctuate from, okay, this year I'm covered, next year I'm not covered? And there's just nothing predictable about that either.
So current wages, the average is like between 135 and 150K is the wage, I think, wage earners that are affected by this statute, at least currently, like to your point, and that's going to change.
I looked it up in Florida, and it's about, for your average county in Florida, it's about 130 is who would be covered by this.
So there you go on that. Now, the second point, the predictability, I just have to say this out loud, and it's a little bit of a convoluted point, but usually an employer, when they have these restrictions for employees, they put them in a contract. They have to be in writing, right? So they'll usually have the non-compete, and it'll be coupled with like the non-disclosure, confidentiality, protection of trade secrets. All that usually is in the same document. And here's where this gets really hairy, because now this new so-called Choice Act, that has to go through the analysis under the Choice Act, but everything else is covered under the old law. So I'm not feeling the ease and predictability here that the legislature cited. Now you have to kind of analyze one employment agreement under two different statutes. That's complicated for an employee. They absolutely need legal advice to travel. It's a landmine. It's an absolute landmine. So, but here we are. We're in Florida, and we like landmines. So this is where we find ourselves.
Yeah, I mean, it's everything about this is so unnecessary, right? Because Florida already had a statute that governed all sorts of restraints on trade, not just non-competes. And there's a lot of issues with that statute that we could probably spend another half an hour talking about. But it was something that at least we knew what it was, and there's laws interpreting it, and so we knew how to kind of apply it, generally speaking. Now we have this new sort of added layer on top of that doesn't replace it, just kind of adds to it. And if someone calls in for advice, now we have to kind of go through all this analysis of, okay, well, if you're a covered employee and you work for a covered employer and they do all this notice stuff, let's go through what the potential liability is here on this. But then if you're not, we still have to go through everything we would have done traditionally anyways. And we don't know which one is going to apply to you, because the person who decides which one applies to you is your current employer, and they get to choose what they want to do under the situation, right? The only choice goes to the current employer. And that's just, there's nothing predictable about it.
So how do we get, I mean, I just sometimes just like scratch my head, like, the Stop Woke Act came, and that sort of seemed like a solution in search of a problem. And now we have, this new Choice Act. We practice in this space on a daily basis. Our firm has multiple restrictive covenant cases in litigation, and didn't seem to be that there was a lot of crying for employers feeling like they couldn't get what they needed from the court system. But now we have this new thing. Again, feels like a solution in search of a problem. Can you shed any light, Gabe? I mean, I know you're sort of the legislative nerd here of the firm, which we love that about you. So where's the why? Like, where did this come from?
Yeah, I mean, we don't have to look far to know how we got here or why we got here, right? There's a billionaire who runs a financial advising company, who the company was based out of Illinois. It was in Chicago.
Ooh, name the names. Let's name the names. Let's say it out loud. Let's give voice to power here. What billionaire is behind this bill?
We'll also do a quick edit for that one, because I actually forgot the guy's name. So Ken Griffin, he's a hedge fund billionaire, had a company that was based out of Illinois, I think in Chicago, but has employees that work nationwide. And he wanted to have additional restrictions on his employees, and Florida said, well, move your headquarters here to Florida and let's see what we can do for you. So the company moves its headquarters down to Miami. He works with some lobbyists in Tallahassee, and suddenly we get this Choice Act proposed. And if you look at the type of industry that is most likely to be covered by this and impacted by this, it's people who work in the financial sector, because there's some very specific things in there that make it incredibly onerous on those types of employees, considering how they are compensated. So, for example, one of the things you have to do, you mentioned there's this, garden leave / in the non-compete a little as well, the sit-out provision. And when you're sitting out, they have to pay you part of your salary. Well, it's very intentionally worded and defined as salary, what your salary is, and salary does not include commissions, bonuses, anything like that.
Interesting.
The way that financial advisors are get most of their compensation, right? If you're a financial advisor, maybe you'll get a base salary of 135 just to be covered, but most of your compensation is going to be coming from your bonuses and commissions, which are not counted in your salary. So if you're doing that sit out period, sure, maybe they have to pay you your base salary, but they don't have to pay you most of what you would get as your compensation.
So if you're in the financial industry, if you're paid as primarily based on commission as the bulk of your earnings, this is something you need to deal with on the way in, right? You need to contract this. This is a very important point. And I hear you on that, because this is something that people need to think about and do workarounds and have counsel for, to make sure that they're protected in this time that they're sitting out. But I would push back to Mr. Griffin, who I doubt is listening to the phone and listening to our podcast right now, because I don't know how this is going to help him, because he's also never going to be able to hire anybody. I mean, this works both ways, right? So you have employees who are, won't leave because they don't want to deal with this garden leave period and this indefinite time they have to sit out before they can take another job. But it also makes it incredibly difficult for companies to bring in people who are bound by these restrictions too. So, I think it's just one issue that creates another one.
It does, but I think what Florida hopes, right? If we were to put on our Ron DeSantis hats and try to figure out why this law gets passed, even though technically
I'm very uncomfortable with that hat, but go for it.
even though he technically didn't do anything and allowed this to go into law, but if we put on the legislature's hat as why they pass this, right? Their hope is this will entice other companies to do the same thing that Griffin's company did, as far as you move to Florida because look what we did for him, we'll do it for you as well. And also one of the things they did in the law, as far as the applicability, is they make it very clear it applies to cover folks who work in different states if their employer is based out of Florida. So it's making it so it tells the company, come put your headquarters in Palm Beach, Miami, Tallahassee, Tampa, whatever it is. And if your headquarters is here in Florida, then this Choice Act could apply to all of your employees regardless of where they are.
So I guess in looking ahead, kind of identifying pitfalls and some challenges and sort of like, maybe I don't want to use the word ambiguities, but maybe that's the right word, and how this is going to be enforced. I mean, we've identified one, there's sort of a question, right, about how is there an interplay between the employer's ability to have this non-compete, a covered non-compete agreement under this new statute, and garden leave, whether one is required for the other. I sort of took for granted that that's how garden leave works, but Gabe makes the excellent point that in the statutory language, that's not so clear.
Yeah, it's really weird because normally garden leave in the traditional context is like it's meant as that's leave where you get paid during a non-compete period, and so it makes sense for everybody to kind of assume like, okay, yeah, this is trying to incorporate garden leave into these non-compete agreements in Florida that are covered here, but they're two separate statutes. It's done separately in here in a way that's really weird, where in theory, as an employer, if you're doing one of these, you could have somebody with a covered non-compete, but not a covered garden leave, or vice versa. And I don't know why anybody who doesn't already provide garden leave would start doing it because of the statute, just at how I'm reading it.
Right. But I do think there's probably going to be an argument that you need to offer that in order to have this broader legal entitlement to preventing someone from working in a similar industry. So that'll be interesting. We'll have to stay tuned on that and see how that goes.
It'll become almost like a consideration question, right? Like what's the consideration this person's getting for this thing that is presumptively unreasonable under prior Florida law?
Yeah, and then the sort of alter ego of Florida thinking that it can prevent employees that do business, even if they sit in other states.
Yeah.
That choice of law thing is going to be a little bit of, I'm sure that's going to get some appellate attention. But we haven't heard much, right, in terms of legal challenges as of right now.
No, I mean, granted, it technically has I guess it's been in law for 6 days now, so it's one of those where we haven't had that 7-day period yet. Like, let's say there was employers on, this law went into effect on July 4th, with somebody sending all of their employees on July 4th, hey, here are these agreements, you have 7 days to go review it with an attorney. So I don't know. I think it's going to be something we're slowly figuring out, and probably going to get more people with questions over the summer. I don't know. There's a lot of things in here, I think, that are very, say, ripe for challenge, right? That there's the injunction thing, which we've talked about a little bit, and it's the wildest part about you can, the court must, upon application, enjoin not only the employee but also their future employer. But if you look at the injunction against even under the non-compete provision, it says the court must enjoin you from providing work to any company besides the covered employer, right? So let's go back to our example earlier of Chewy, Kroger, and PetSmart, right? I work at Chewy. I leave Chewy. I'm going to go do a job at Kroger, and Chewy says, no, that this is a covered non-compete, and they're similar to us. So they file their lawsuit, and the judge must enter an order telling me I can't work for anybody, Kroger or otherwise. And so now I'm stuck. The only place I can go work is back at Chewy, who, why would they hire me back? I already left, right?
Right.
And so even if I wanted to go work at, I don't know, I wanted to go work at I keep wanting to say Radio Shack, like that company still exists, but I want to go work somewhere else. Like it doesn't matter. The judge must tell me, no, you can't work anywhere except Chewy now. And that
sort of underscores the irony that the act is called the Choice Act, doesn't it?
Yeah, exactly. It makes no sense at all.
And I think we probably should be clear about how this bill passed. So there was 81 bills submitted to the governor at the end of the latest legislative session, or some extraordinary. I think I got the number right.
It was more than that, but there was 84 was the number that was last or 2 Thursdays ago, because there was there's the whole snafu with the budget where the governor and the legislature couldn't agree on the budget, and they finally got past whatever that was and agreed on a budget. And then the day after the budget was finalized, the legislature said, hey, great, here's these 84 bills that we passed. You have 14 days to sign, veto, or do nothing. And, this was just buried in there.
And the governor didn't sign it.
Nope.
He didn't veto it, so it became law by default by doing nothing.
Right, because the Florida Constitution has a weird quirk where the governor doing nothing, unlike, federally, we have like the pocket veto, right? There's the thing of the president does nothing, and it's a veto after 10 days.
Right.
Florida's Constitution says, no, if the governor does nothing, it becomes law.
But this happened under his watch, and I think that's important to say, and it happened without, it seems like, a lot of attention. And prior to this podcast, I do want to say that we reached out to numerous legislatures in the state of Florida and invited them before the bill became law to have a roundtable discussion, to talk about it, to invite lawyers who represent people on both sides of the table, employers and employees, to talk about it so that we could have a bill that actually works for everyone, or at least have it be a conscious decision, right? Like, so you're not just like putting words on a piece of paper that say, this is what's happening, without at least thinking about what's currently happening in the legal structure of that. And not a single one took us up on the invitation. So now lawyers will have to figure it out, as we always do, and represent our clients to the best we can. I think the best advice we can give any client, and you mentioned it for employers, definitely need to get some drafting advice on how to comply with those notice requirements. Employees also don't sign until you have it reviewed. 7 days is a short period of time, but you can get in to see a lawyer if you're diligent about it and you call. We have an intake process that's kind of like urgent care for employees, so you can call and get on the schedule and speak with an attorney, which I think is critical here. So we got your back. Any other final thoughts on this and other employment hot topics, Gabe?
No, I just, I would think it's interesting that the party who has always been the non-pro-choice party is suddenly the choice party when we're talking about non-competes.
Yeah. I guess we could ask where was the opposition party in opposing this? But I think in terms of numbers, they really didn't even have a shot, right, at the Florida legislature session. So strange days ahead. Florida's going to be a place for preventing competition, I guess. So it'll be interesting to see how it plays out. Well, stay tuned. This is Cathleen Scott, and we'll keep you posted as always. Thank you for joining the Cathleen Scott podcast. Thank you so much for tuning in to the Cathleen Scott podcast. We hope this was fun and informative. We'll catch you on the next one. You can find us online at scottlawteam.com or floridalaborlawyer.com. Thank you for joining.